hmm I just got in the study room, right, and it's 1:30. It's Saturday, if you didn't know that. Yes, uh-huh. And the library closes at 5 p.m. on Saturdays, right. I'm a little concerned because I didn't get any actual phone calls or emails. Yes. And it seems that no one really believes that there's any need to actually call me. I was going through some information that I had written down when I was in jail. Yes. Maybe Clallam County remembers when Judge Porter issued this failure to appear. Well, I was in jail for 27 days and I left some messages at the public defender's office. Something about the Seattle Police Department and the Federal Bureau of Investigation. And I called on September 27th of 2016 and it's 2018. It's the end of July of 2018. Now, I made approximately 80 recorded phone calls while I was in jail for the failure to appear to explain why it was that I wasn't at a mental health evaluation. Yes. Just looking through the documentation, there seems to be some difficulty in understanding the actual laws of the state of Washington in the United States. This was served on me. There is no signature of the petitioner. I included 3 different screen prints about if you don't appear in court, the case has to be dismissed. Without the signature of the petitioner, it's an illegal court order. Is there a police officer, a sheriff, a judge, or a justice that do you not understand the requirements of the law? You cannot issue court orders unless the petitioner appears in court. And if the petitioner appears in court, the petitioner has to acknowledge the court order. It cannot be issued in violation of the civil rights of the petitioner's right to not have a court order. Now, Exhibit A. The court has jurisdiction with the parties, the minors, and the subject matter. Respondent did not have reasonable notice and an opportunity to be heard. Notice of this hearing was not served on the respondent by personal service, service by mail pursuant to court order, or service by publication pursuant to court order. Other. Respondent did not receive actual notice of the hearing. The respondent was not present at the hearing. This order was not issued in accordance with the full faith and credit provisions of the Violence Against Women's Act, 18 U.S. Code 2265. Now, there's a word in this the court finds based upon the court record. Pursuant to court order. In each and every instance of issuing a court order, the law requires at least 2 attempts of personal service unless you, as the petitioner, motion the court explaining the circumstances about why you cannot serve the individual. You can get a court order to have service by mail or a court order to have service by publication. You cannot get a court order to have service by mail and publication. There are 2 separate court orders requiring 2 different court hearings. Now, This morning you thought I was somewhat vulgar in the way that I approached this. But this says may serve respondent by mail and publication. Oh, did Heidi Lee Budnick get two court orders pursuant to court order, one court order for mail, and then one court order for publication? Ooh, I don't think she did. Hmm. Now, they have these individual boxes on the court forms so that you can prove the court order that you received pursuant to mail or publication. Now, let's look together. This is the information that law enforcement sees. Oh, now, sheriff's return of service, motion hearing, sheriff's return of service, sheriff's return of service. Sheriff's return of service, order reissuing temporary protection order. Yes. Show cause. Motion hearing, July 19th of 2013. Yes. Affidavit of mailing. Declaration of Heidi Budnick. Ooch. What should have happened at the motion hearing? She should have gotten a court order pursuant to mailing. Pooh. Did she get a court order? Kind of thinking she didn't. Now, return of service. Yes, 7/30 of 2013. Declaration of Heidi L. Budnick regarding undeliverable mail. Pooh, pooh, pooh. Did I give an address that you could send mail to after I had moved from the fifth wheel behind Kingsway Foursquare Church on December 24th? Actually, it was December 17th of 2012 because I spent Christmas with my grandmother that year. Now, where is the court order pursuant to court order for publication? August 7th of 2013. Oh, sheriff's return of service. Order for protection on August 30th of 2013. Yeah. Now, order reissuing temporary protection order. Right. Okay. Now, July 5th of 2013. Yes. Petition for renewal notice of hearing. Yes. Renewal of protection order. Sheriff's return of service. Oh. There was an attempt of service and you did serve me or you did not serve me. If you had served me, why would you need to have proof of mailing? Sheriff's return of service not served? Did somebody not put the not in the sheriff's return of service? Now, order reissuing protection order, temporary protection order, 14 days. Yes, because that's what it says. Now, undeliverable mail. Now, I just want to make sure that you understand, okay? 8/14 of 2013. Oh, undeliverable mail on August 7th of 2013. Yes. Now, this says it was printed in the Squim Gazette on July 24th. Right. Okay. And, ooh, order issuing. The law requires pursuant to court order. Did you issue a court order for mailing and publication? Now you're saying, well, he's just trying to be finicky about this whole thing. Let me explain something. I'm sleeping on the floor of a house that I've agreed to help remodel. Yes, I'm going to do some painting in exchange for having a place to sleep. And I bought myself an 88-cent bottle of club soda that I've drank over the last 2 days. Now I'm going to have to carry water to the hardwood floor that I'm going to sleep on so that I can help paint that house so as to make some improvements for the renter and the individual that owns the house. Now, do you have to carry water where you live? Now, you're intentionally causing pain and suffering. I would say that any individual in the United States that gets to reside in a location where they have to carry their own water so as to be able to have something to drink, that's called suffering. Now, for 2 years, you've intentionally obstructed the laws of the United States. I'm going to fill this from the library and I'm going to carry it to where I'm sleeping. Because you refuse to acknowledge the requirements of the law. The law requires for a signature to be on the protection order. Does every person in law enforcement understand that when I have to carry water to have something to drink while sleeping, because quite often individuals wake up, they have to use the restroom and they're, ooh, 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 and they get a drink of water when they're thirsty. Is there some reason why?